Virginia State Bar Young Lawyers Conference, as he spoke to before, where he oversees the Professional Development Conference and has expanded the YLC's social media footprint. He also won the Edwin Burnett Young Lawyer of the Year Award in 2013 and is currently a fellow of the American Bar Foundation and the ABA Young Lawyers Division. He graduated from the Appalachian School of Law in Grundy, where he served as its Alumni Association president and started its social media presence with Facebook. He's also a proud graduate of JMU, and he's married to Brittany Fortier. Shemeka, whoops. I don't know, I think I zoomed in on you. Oh. There you go. I won't touch anything. Shemeka is a graduate of Regent University School of Law and a proud member of the William and Mary Tribe, where she attended undergrad. She has been barred in Virginia for just shy of 5 years. A little more than 4 of those years have been spent as a prosecutor for the city of Norfolk in the Commonwealth Attorney's Office. Before joining the Young Lawyers Conference Board of Governors, she served as a project manager for their Minority Pre-Law Conference and No Bills Night program. Outside of the Virginia State Bar, she has served as the website and social media coordinator for the Southampton Roads Bar Association, which was named Local Bar Association of the Year by the Conference of Local Bar Associations just this past year. Obviously, to know anything about what is going on today, she spends a portion of her time active on social media platforms. Outside of that, she's a professional singer, a huge fan of anything Norfolk, her hometown. Did I say that right? Norfolk? I don't know. And enjoys going to the movies. Welcome, Chris and Shemeka.
Thank you for coming again. Thank you for seeing me again. I'll just say it's great being here. One note about me, I actually grew up on the peninsula, so that's why I'm here. It's a good excuse to see the parents, so that's why I'm here. But yes, legalities of social media. Why don't you start us off, Shemeka, and I'll put some support on the back end.
Jump in whenever. All right. It's good to see a lot of familiar faces in the crowd. Also slightly nerve-wracking because Chris asked me to be a part of this presentation due to my new role on the Board of Governors with the Young Lawyers Conference. And I was kind of like, oh, God. I mean, I'm a good trial attorney, but just like a random public speaking person, probably not the best. But I hope that this presentation will provide you guys with a lot of good information in regards to kind of navigating the seas. Obviously, as Chris and I will both tell you, this is not legal advice. And if it was legal advice, it probably wouldn't be all that great. But I think every single one of us has seen something on a social media platform or website or something along those lines that really just made us go, oh my God, why would you put that on there?
We just want you to have something brilliant to say when somebody starts talking about, oh, I'm thinking of expanding my business to Facebook or something like that.
So you could maybe give them a little bit of insight or direct them in the right direction when some of these things come up. I guess basically at this point in time, we're going to explore a lot of different areas, so we have a little bit of time to cover a lot of information. Basically, if you miss anything, I know Chris has probably already said we record these and they are put up later on so that you could go back and kind of review some of the things or some of the tips or websites or resources that are given during the presentation. We kind of just want you to be able to talk to your PR people and hopefully steer them in the right direction, kind of like, I heard something about this, we probably shouldn't do that based on these things in order to keep you and your clients or everything safe and protected. Before we get started though, Chris and I want to definitely promote all of these social media platforms that we work really hard on that involve the Virginia State Bar Young Lawyers Conference. We are everywhere. So you see we have a presence on all of the major social media platforms, our website. We encourage you to like our Facebook page, tweet us, we have an Instagram, and it's mostly things about what's going on in the Young Lawyers Council conference right now, different things we're meeting about, and we do try to provide information about our upcoming CLEs and meetings, and there are a lot of kind of blast about that. So we think you should follow us. You'd probably learn a lot. It's a volunteer organization. So we're working really hard to get really good information out to you. All right. As I said before, remarks are our own. They do not reflect those of our employers.
I need to stand on stage for this one too.
Our employers, the U.S. government, Social Security Administration, Norfolk Commonwealth Attorney's Office, the Virginia State Bar, or even the Young Lawyers Conference. These are basically our own personal remarks. As we already said, it's not legal advice. We expect you to seek out a lawyer who knows more about these things, seek out PR people who know more about this area, because it will be specifically tailored to your set of facts and circumstances. This is general information, so you would need somebody to specifically listen to what set of facts you have in order for them to give you the proper sort of advice.
Yeah, we're going to cover some intellectual property topics. We're going to cover some employment law topics, very briefly, very superficially. So that's what we talk about when we say go after your own counsel, somebody who specializes in a particular issue for a specific instance.
So what is the point of this? What is the goal? We want none of you to end up being the test case. We don't want, Supreme Court versus Midgley out there in the world. That's not what we want. So we want none of you to end up being the test case. We want you guys to have an idea that this is a newer area of law, and it's a path to kind of keep you a little bit out of the trouble zones. Obviously, it would cost thousands of dollars in litigation and all that time prepping it, and however long it took to get the case through the court system, and then lawyers would forever associate you with being the case that figured out what you shouldn't do in regards to social media, website presence, those kind of things. So we want you guys to kind of take this kind of as a little bit of guidance to keep you from being that guy. Also remember, a website's terms of use will not protect you. It always protects them. Their lawyers get together and design something that is designed for their company and protects them. So you will not be protected by that. We want you to, your lawyers would know this off the top, and the lawyers who involved with them, you have not paid $1 for those people. So that means you have to protect your company on your terms and your employees who are working for your organization in the same way as social media is part of that. So this means don't be shy. Out with it. Do you want posts that are vulgar? Probably not. Do you have a decency policy, a sexual harassment policy, or a commitment to diversity statement? State that in your policy. And this is when we're talking about what your social media policy is, and we're going to get more into that in just a second. It means stating things like post in violation of the things that you think your company or your company or your employees represent, they will be removed. So anything that's associated with you, you want to have a social media policy that defines that. So like I said, where will we end up going today? We're going to talk about, well, first I'm going to talk about social media policy basics, property issues, sort of images and that kind of thing, music, that kind of stuff. Who owns those things? Chris is going to get into things that deal with employment, regulated entities, and litigation privacy. And then I'm going to come back up and talk about social media advertising. So like I said, we have a lot of topics to cover, but hopefully you'll be getting some basics that will help steer you in the right direction. Also, some of the resources that we use, and so obviously just copying these down would be a little bit complicated, but like I said, they will be up later, so you can see them later. These are some of the resources that Chris consulted in trying to prepare the presentation. I read through some of them in the last couple of weeks. I haven't probably done as thorough of background on them as he has. But the VSB Technology and Practice of the Law Committee, I have done a lot of research in that area, looking that up for past things. So these are all areas and resources that you could look into. So you might be looking for guidance on how to craft a social media policy, what should go in it, what things how you should define the terms that are there. These are places that you could go. Because local bar resources, the Virginia State Bar and the ABA being a bigger bar, they present regularly on these topics. If once you leave here you haven't gotten enough of me or Chris, you can look further into those resources. And the topic is actually pretty regularly written about, and by regularly I mean about once a year in the Virginia Lawyer Week, the Virginia Lawyer magazine. So that's another way to keep up to breast of kind of changing things that are happening in this area of the law. All right, so we talked about where we're going to go. So first things first, having a social media strategy. The biggest thing that you have to decide first is, do you know how to use each of these platforms? Obviously, as you saw at the Virginia State Bar Young Lawyers Council, we have a lot of different platforms, but that's because at least Chris or I or both know how to use every single one of those platforms, and we have an idea of how those platforms are going to be used to benefit the YLC. If you don't have an idea of how the platform is going to benefit your organization, it's probably best that you don't start on that platform just yet. You need to have a strategy, and then secondly, how many accounts? At this point, our kind of recommendation would be the fewer, the better. But you are not going to be able to get as much exposure by having a limited amount, but you will be able to control better unless you're going to hire someone that does social media only. If it's going to be you and maybe your assistant or maybe one of your employees that does it, you're going to be able to control better what's out there and know exactly what's happening on each one of your social media accounts if you have fewer accounts. The more accounts you have, the more liability you open yourself up to, because those are the amount of things that you're going to have to monitor and know what's going on with all of those pages. So pages or accounts. So at the beginning, we recommend you start off with fewer accounts because that will obviously benefit you in knowing what's going on and limiting your liability. Social media policies. Okay. If you have social media, you need to have a social media policy. That's end of story, no going past it. If you have social media and your organization is using it, you need to have a policy as how you, your employees, and other people who are interacting with your page should be governing or conducting themselves. Obviously, you can't control the greater public, but you can talk about what your message, your mission, and how you want people to comport themselves to activity on your page. Then, so if there's something goes wrong or there's something that's outside of the guidelines of what you think your social media policy should be, then you have reasoning for removing someone's post or something along those lines. It has to be clear that this is how you govern your social media page. Chris will talk more about this later, but communicating the social media policy to your employees is also very important. It should kind of be from the very beginning, probably a part of your employee handbook, on your company website, and if you can put it there on your social media page. Sometimes that means you want a link from whatever site you're using. So if you're using a Twitter, if you're using something else that doesn't give you a lot of space, you want a link from that page to another page that has room for you to put your social media policy. We've seen a lot of bad posts out there that cause your fellow social media professionals heartburn, and they could create major threats to your organizations, your bosses, and your fellow employees' livelihoods. As a reaction, I would hope that many companies were evaluating their social media policies, okay? And that means regularly, yearly, or when you add or subtract a new platform. So if you were working, your company was only working with Facebook, and then you had LinkedIn, and then the next year you decided to add Twitter, then you should be reviewing your social media policy as soon as you add a new platform to the group that you already have, because it will change how the dynamics and parameters, or you might need to add something specific that only works for that platform. So you want to be reviewing those things regularly. I know Chris has suggested this year that the YLC, we review our social media policy because we've added some things and changed some things over the last, I think, 2 years, 3 years since we...
It's been 3 years since we wrote it up, so it's time for a review. Even if you don't modify your social media presence, a good review is always good every couple years.
Exactly. So we're going through that same process right now, just trying to look and see if there need to be changes or if there don't need to be changes to the social media policy that we're currently using based on all the platforms that we use. All right, so a couple of examples, and I know you guys are looking forward to examples. So this is the social media policy for Walmart. Some of the things we like about it, definitions on how they will use their social media. This is how we use Twitter. If you have a problem on this issue, reply here. It's important that you know exactly kind of, like for instance, please note that any customer service post published on a Walmart page by customer will be removed when discovered. Okay, and then, so they're basically telling you at the point, like, if you have a complaint about Walmart, this social media page is not where they want you to put it, and it's going to be taken off. So you can't go and later complain, like, Walmart didn't listen to me, they just took my post down, they didn't care about what was going on or my problem. Well, they're clear that says, please note that any customer service post published on a Walmart page will be removed. And it says, though, however, if you'd like to comment about customer service or any other issue, you can call us, or there's a specific page for that. So they are clear about what they want for this page, okay? And so once again, this is kind of what we like about a social media policy, trying to be clear and definite about what they have going on. A little bit super clear is the Air Force blog assessment. Obviously, it's a very comprehensive flow chart. It gives you yeses and nos, trolls, misguided, unhappy customers, and kind of goes in. But it does go down to the bottom and give you blog response considerations. So you know at least how they're considering the information that you're getting. They have contact information at the top, which just for if some reason you can't get through this flow chart, there's another way to get in touch with them. There's an email. There's also a phone number. There's an address. Yours does not need to be flowchart comprehensive, but relaying a strategy and the policy in this way explains to your audience how the job is done quickly and efficiently. So it's telling them what happens when they go through the process is also important. All right, this is the Best Buy social media policy. Be smart, be respectful, be human. Best Buy has a kind of a sparse one in a sense, as in it's not a lot of paragraphs, it's not too much information. But what they do want you to know is in bold, what you should do, what you should never disclose. So they underline it, they put it in bold so that you have kind of bullet points in which to follow. Sort of things like act responsibly and ethically, honor our differences. So basically their social media policy is about being respectful and obviously conducting yourself and how you conduct yourself on the internet. At the bottom of the page, they've referenced the other policies that apply to their postings, which would include customer information, code of business, information security, securities trading. So like we said, if there isn't a place on whatever platform that you're using, you should have a link to your social media policy. So obviously they have enough space on this page to include all this, but they did not have enough space to include some of these things about their policy against sexual harassment, their policy against all forms of harassment. But there are links on this same page that will take you to more information about each one of those policies. All right. So that was quickly social media policies. If you want more information, very simple website that you go to, socialmediagovernance.com/policies. It's a central database of social media policies from governments, nonprofit organizations, and companies from around the world. So this is a good place to go to glean an example from a lot of different places on how to put together a social media policy. All right, so moving on. Who owns this stuff? So we're going a little bit deeper into who owns some of the content that you're posting on your page and how to make it clear of who owns the content of what you're posting on your page. There are three big issues you need to clarify in your main social media policy about content. 1, who owns the content? 2, is the content copyrighted? And 3, who owns the social media account? And we will show some examples of that in just a minute. One thing you need to set out at the very beginning is who owns what. You must consider who owns everything and set this out for liability reasons, as you may want to disown certain things such as criminal activity, protected materials, and nasty comments. Obviously, you don't want to be associated with those things. We know now that blog owners and social media owners are responsible for the material that is on their accounts, whether it be something they generate or something another user of their site generates. That is the current law, but we may see a change, especially as social media accounts owners are required to register on websites, and these accounts get posted with photos of your face. Okay. If you want to claim ownership of something someone does on your behalf, you must get permission. So I know a lot of you probably have gone to a lot of different events lately where there's a photographer there. And if you probably read fine print, like basically your attendance at the event is giving them permission to, 1, take your picture, and 2, use your picture in promotional advertisement or something along those lines. That happens at a lot of events these days. If you go, you are kind of implicitly, for most of the people, saying, well, I know this isn't the applied thing. I'm going to consent right now. You can take my picture, you can post it. The only way you kind of disassociate yourself with those things is if the photographer comes around, you go, no pictures, please, no pictures. So they want to be clear at the outset. So if you want that ability, you want to have a form ready to go and ask each person to allow you to publish work as soon as possible. Waiver forms are easy to find and replicate. Also, independently verify any copyright. How do you do this? Google any line of a document, any line of a paragraph or text phrase in a piece, and then if it matches with something word for word on the internet, there are probably copyright issues. Don't use it in your post. Also, make sure you have clear guidelines in your policies about who owns what social media accounts and how these accounts can be used. And like I said, we're going to talk about that a little later. To include our good friend Grumpy Cat, memes, and how you make memes. The original picture, if someone owns this original picture, if you make it into a meme, you might have copyright issues. And I say might because, again, there are other people who are more versed in what copyright issues are out there as far as photos, music, all those type of things. But these are kind of things that you can run into. Copyright in social media is not well defined. Okay. My thought is, or Chris's thought is, if you can't do it in real life, you can't do it on social media. We have not had a significant litigation nor the federal or state rulings in detail. 1, if you can't do it in real life, do not do it on social media. The courts have not seen any difference lately between social media and other types of media, so print media, that drastically alters rights and responsibilities of users/posters. In the spirit of our don't get in trouble theme that we have going on here, just think in terms of real life. Would you do something like that to their face? Okay, so that's what we want to kind of think about when you're doing a post in social media. Second thought is that everything, not everything, but most things have the potential to go viral. If this was spread out far and wide, do you still want to be associated with it? If you do something wrong or if it's weird, expect people to see it. And if you have a lot of enemies, expect even more people to see it. If you've not gotten the point already, you will need to monitor closely for copyright infringement. The sad thing about our world is that our properties can go from legal to illegal in a flash. For example, Pinterest, as discussed in the social media panel in St. Paul, Minnesota, your bulletin boards are probably full of content that comes from outside of your organization, if your organization has a Pinterest board. Some organizations do. It depends on what exactly you're trying to sell or what exactly you're trying to promote. Mixed with content that's from inside your organization. Make sure you are aware of what is yours and what belongs to outside content. So you want to know the things that are posted that originated from inside of your company versus things that you pulled off of the internet that did not originate inside of your company. That is very important. You may even want to mark or in the caption on your pins who made the content. Most people will love that you pin them on their boards, but they may be a few who don't. Don't ask why, they'll eventually tell you. While the concern is minor, acknowledging the author and stating the contact is not something that we made, but we highly recommend to you or the like or whatever, should alert the user exactly where the content is coming from, so you won't have any problems as distinguishing that you're claiming something that was your own that is not actually your own. If you really like someone else's content, here are a few things you should do to make it look like it is not yours. Quote, indent. There is still the standard notation in writing to show where you are quoting someone, okay? So this is all towards Bible. Ask permission, credit profusely. Obviously, if you ask permission, you get a no, don't do it. But if you ask permission, it's a yes. But you still have to give the credit after you get the yes. You still have to make sure there's association showing that you did have permission, and then give them credit. Hat tip, HT, the creator. So that's something you can do also to show that it belongs to you. And circling back up, careful with memes, as we talked about. Getty and National Geographic entered into an exclusive agreement where Getty is going to be able to post things from National Geographic, but if you're pulling something from Getty's images, they probably belong to someone else. They have a whole portfolio of images that belong to someone else. So you have to be careful about how you're creating memes or things of the like so that does not cause a copyright issue. Photos and video, okay. General photos where you have no clue who the people are, that works. So if I was standing on this stage or a little bit further back and I took a picture of this room, it would be very hard to kind of individually distinguish who every single person in this room was. I'm going to take a step back. It's like someone had to kind of blow up the picture really large in order to identify every single person. Okay, general behavior like that, where it's the general photos and you don't know who people are and it's hard to determine, that's okay. If you want faces, place prominent notices in your registration materials or signs that you will take photos for social media. So we've already gone over this. And that their attendance is consent to do so, and signed consent is even better. So like I said, a lot of things when you register for them will say, we plan on taking your photo. If you attend, you know that we're going to, and this is your agreement that we will and are going to use it later in promotional materials. What would be even better is if when they got there, they had to sign a separate waiver stating, you are going to be featured in photos. We are going to use those photos later on in promotional materials. You agree to that by signing this form. If you're choosing photos from your events to post on your social media, you should be able to easily post those photos where no one is identifiable, okay? That connects better with your customers, though, if you can kind of see who the people are and kind of the people who are looking into your social media want to be able to connect with people because they want to be like, oh, that person's like me. So that's why you want to move towards an effort to get agreement so that you can use people's likenesses later on in your post. Tell your attendees that if they do not want their photos taken, either don't attend the event or let the photographer know not to take their picture. Post this social media agreement in the registration materials, event brochures, event programs, signs at the registration desk, and anywhere else you think is appropriate. Place your social media platforms on these notices, so you use YouTube or Instagram, make sure that they have some kind of notice that you do use social media, and invite your event attendees to follow or even interact with their own materials and post impressions. But don't forget to let your attendees know that if they share a photo, it is no longer theirs. Moving down just a little bit. Keep the kids out of it. Adults may not mind their faces on social media. However, there is an entire body of law called the Children's Online Privacy Protection Act that governs photos that involve children. Placing children on your photo or video streams can create some really visceral reactions from your fans and social media public. So you want to kind of be careful about that. If you are a company that caters to children or has products that involve children, that is one thing. But I would urge you to keep the minors out of your social media photos and video, especially if there are no parents present. There is that body of law, the Children's Online Privacy Protection Act, which creates a special set of permissions and actions you need to be aware of if you're going to base content which is submitted about minors. This is under the age of 13, including photos, videos, and geotags, the place and time of your photos. If your organization deals with children and children's events, you need to be aware of this act, which is administered by the FTC. Finally, if someone asks you to take down a photo, cease and desist, just do it. It will save you the pain of litigation, headache of bad PR. All right. So really, who owns this stuff? Okay. Eagle versus Morgan was a case involving a LinkedIn account. Basically, it was from 2013 in Pennsylvania and provides some good thoughts about how you should conduct who actually owns your accounts, who actually owns the things that are on your accounts. The plaintiff had a LinkedIn account. Plaintiff gets hired by a company called EdCom to be its CEO. Plaintiff has EdCom employees assist with maintaining her LinkedIn account, giving them password access. Plaintiff gets fired and EdCom changes the password to her LinkedIn account, locking her out of her own account. EdCom changed the profile to its new CEO, even though the URL of the account remained linkedin.com/Linda Eagle, who was the plaintiff in the case. And a Google search of Linda Eagle would return results to this URL. The plaintiff recovered access to her LinkedIn account 2.5 weeks later, but obviously the legal battle went on much longer than that. The court held EdCom liable under claims of unauthorized use of name, invasion of privacy by misappropriation of identity, and misappropriation of publicity because it took over Eagle's account and replaced the content with Morgan's information. But Eagle recovered nothing because she couldn't prove damages, that she was actually harmed by the actions of the company. So, if you want to control an online profile, you need to have a policy requiring such a profile and then invest time, money, and resources into managing such a profile. When you do that, you are the party with the contract with the social media, so you or your company, not just your employee. So you can't, if you co-opt an employee's social media and start using it as your own, you're going to run into some trouble. You will have to build the employee's contact list through investment of their time and your money as opposed to your employees, and that's why EdCom did none of that, and then they lost. Phone Dog versus Kravitz. Okay, a guy named Noah Kravitz gets hired by Phone Dog and opens a Twitter account, PhoneDog_Noah. A long time later, he quits the job and changes his Twitter to Noah Kravitz and keeps the followers he made at the company. Phone Dog then sued him for the follower list, claiming it was proprietary information. Phone Dog failed to allege how Kravitz continuing to use the Twitter account in his own name disrupted the purported relationship between Phone Dog and the Twitter users, or how it resulted in economic harm. Two essential elements for those claims. So they basically lost. The major problem is that Phone Dog does not allege that it had an employment agreement or confidentiality agreement with Kravitz that would have protected this information, or clearly stated that this information should be treated as confidential, proprietary information. Therefore, they lost the case. A friend or follower list is not a trade secret if your policy does not state that it is. So basically, he can take all of those followers with him at any point in time because there was no clear guidance as to how he was supposed to conduct himself on social media while he was an employee of the company, and whether or not starting Phone Dog Noah basically entitled the company to anything that was attached to that account while he was working with the company. So you have to be very careful when employees do something, especially if it's in your name, if there are no clearly defined social media policies or lines. So, our advice, Keep personal and professional separate. Do not force your stuff onto an employee's personal pages. So obviously you can't require, or you could, but you have to be clear about it. You can't require your employees to post things on their personal pages for the business. If you want them to have personal business pages, that's completely separate. And I know a lot of kind of examples that I would use there are realtors. A lot of realtors involved with maybe Chantel Ray or some of the other kinds of, they have business pages that are separate from their personal pages for their friends and their family. But they have another page that's set up that's completely open to the public, which does promote things like housings, open housings, things that they're showing. And those two things should be kept separate. Put time and resource to build their professional pages. So if you want to have more control over what goes on those professional pages, you have to invest in those professional pages. Clients, vendors, trade associations may be your targets. Figure out what your employees should be posting on these pages. So it should be a joint effort between you and the employee so you know exactly what's going on the pages and you have some modicum of control of how the pages are being posted and what's being on those pages. Employees can invite their personal friends to like a page if they wish, and that obviously drives more traffic when more people are associated to a page. So you want to tell them, yes, you can invite your friends and family, but as long as their friends and family understand that this is your professional page and that's how it's explained in your social media policy. Define what's yours and mine in the policy, so make a distinguish between you and your employee, what you own and what they own. So we're going to switch to Chris's portion for a little bit.
Thank you, Shemeka. Just going to put this right here. Very good. Let's go on to talk about things. Yes. We talk about proclaim and don't disclaim? Yeah. No, we didn't? Okay. I can recover it. Yeah, so basically when I talk about proclaim and don't disclaim, it means establishing pages that clearly mark your brands. Make it clear how the employee is interacting in social media. In reality, the less ambiguity you have that you're showing, the better off you are. When I say do not be afraid of the transition, I mean set out a clear policy, set out a clear checklist so that when somebody is leaving a job, you have an orderly transfer of things so that basically the employee can say, hey, I'm leaving X company to the contacts, to their contacts, their Twitter followers, their Facebook friends, whatever. Make sure that they can announce it, and in their announcement they say, if you want to keep following me, you can have me here, or you can have me at X address. Or if you want to continue following announcements from the company, please follow my successor blank. That's simply what all that means. And that's also, of course, a chance from the public relations perspective. This is a good chance to welcome this new person into the company and invite their followers to continue to keep following. So let's go on to something a little more fun. We're going to talk a little bit about employment. As you see here, I have a woman and 3 pierogies. Why would I have a woman and 3 pierogies? We're going to illustrate a little bit of a difference here. Let's talk about the woman. This woman's name is Denise Holmes. This story is a little bit old. It's from about 4 years ago in 2012, late 2012. So she was somebody who made ice cream at a Cold Stone Creamery in Sacramento, California. So she basically was a little bit frustrated with how the election went and decided to vent her feelings on Facebook. Basically, she said something along the lines of, I hope somebody assassinates the president. That's what her actual remarks were. Well, of course, guess what happened? Anybody? It went viral, exactly. The post went viral, and suddenly people started putting 2 and 2 together, and that she was working at the Cold Stone Creamery in Sacramento. So, of course, considering this is a political post, they start pressuring people, all these people start coming and pressuring Cold Stone Creamery to do something about her. Well, there was that little thing. The reason why Cold Stone was able to fire her was that there was this little clause in the contract that said, don't violate U.S. law. Usually that's in everybody's employment contract, I would assume, right? A little clause. Well, there's also a part of the U.S. code that says, don't threaten to assassinate the president. That was the code that she broke, and of course the Secret Service paid her a nice little visit, and Cold Stone was able to fire her because she violated in her social media post that don't violate the U.S. law clause that basically was allowing her to get fired. But not all nasty words result in firing. I'm going to turn your attention to the three pierogies. As you all know, anybody here from Pittsburgh? And you know what happens with the pierogies, right? Just like in Washington, D.C., we race presidents in the fourth inning. They race pierogies in Pittsburgh. It's actually a pretty cool thing to watch. But basically, one of the pierogies, I'd say back in 2010, 2011, was a little upset about the Pirates' personnel decisions. I think in about 2010, 2011, the Pirates had endured about 19 or 20 straight seasons of losing. And, to be in that organization with that losing streak for that long was frustrating. Well, the Pirates decided, trade deadline's coming up. Let's make some trades. The pierogi seriously disagreed with the trade. So, of course, being all upset, he decided to vent his feelings on Facebook, like any sane person, right? Yes. Well, he immediately got fired. But there was one problem. There was no procedure in the Pittsburgh Pirates employee handbook, I'm assuming their policies or their handbook, that discussed this sort of situation, which was essentially publicly shaming the Pittsburgh Pirates, which their record at the time, they had a 19-game losing streak at the time. So I don't know if you could go much further with the shaming, but they decided to fire him. But then one of the attorneys was like, wait a minute, you can't do this. He hasn't violated any policy. I mean, nothing that says you can trash us on social media. There's nothing about that. So eventually they had to re-offer him his job, which they did just in time because there was a minor league ball club about 30 minutes down the road in Washington, Pennsylvania, that offered him a job as one of these racing mascots. I'm not sure what the baseball team in Washington, Pennsylvania is, but yes, the Pirates managed to offer him his job back. He basically took the job back, and now he's still a happy racing pierogi. But the main point of this is, if you don't have language in your employment or social media policies, you could be in for a wild ride. And you'll be employing one of my colleagues, PR people will be employing one of you. So I'm encouraging more work by doing this. I know we've talked a lot about employees, the employer-employee relationship, a little bit about the public. But I want to get in a little bit about corporate governance, what your boards of directors need to know. Usually, if these folks are older, they may not be as well versed in social media, or they may know that their children are on social media, but this is a good time to remind them, watch what you say. That includes watching what you say to your children. Remember, the SEC is watching you. It's just like your emails. It's just like your press conferences. It's just another way that you're broadcasting information out to the public. Yes, that includes your likes and your loves, your simple one clicks on Facebook or Twitter, or even reacting LOL to something. Don't ask me why. Those could be perceived as endorsements. Remember to warn your corporate officers and board members about this. Train and train regularly with these folks. Just make sure that they know what to say and what not to say. I'll even give you an example. So not necessarily a corporate director, but the same concept. A couple of years ago, there was a headmaster at a school down in Florida. He basically got fired, and they basically Basically, they were in litigation, the school and the former headmaster. So they eventually came to a settlement. This settlement was $80,000. Why am I telling you terms like this? Well, hold on one second. One of the terms included a non-disclosure of the settlement. Basically, it had gone on for years, and then there's the father who was the headmaster. The term said he could tell his wife, so he told his wife. Well, eventually, he ended up telling his daughter, because apparently this whole episode had been very stressful on her and everything, and so they told her, yeah, you know, we've settled, this lawsuit's over, we're going to be getting $80,000 out of this. Well, guess what the daughter decided to do? She decided to vent her frustration like this. This was on Facebook. Does anybody want to venture to know what happened? Nobody? I'm going to say this. This was not her face about a year later. Basically what happened was that the school eventually took the family to court, saying that the daughter violated the non-disclosure agreement. Well, actually, not just the daughter. They said the former headmaster violated the terms of the non-disclosure agreement by telling his daughter, and his daughter broadcasting it. Of course, word got back to the school. Remember when I said that the school said he could tell his wife? Did I mention that he could tell his daughter? No. So that's how he violated that particular agreement. They eventually received, who wants to guess how much the family eventually got? Nothing, exactly. So that's the moral of the story. Drill down. Initially, when this first story came out, it was educate your millennials moment, but no, this is not just an educate your millennials moment. Most of your millennials will know something about this. This is an educate your board of directors, your parties and lawsuits, your older folks who just think casually of just telling the kids. You could get away with that maybe 15, 20 years ago. Not today. So let's talk a little bit about freedom of speech, First Amendment and moderation. So when I did this, of course, I started doing the social media for the Young Lawyers Conference circa 3 years ago. At the end of my first presentation, one of my fellow board members, brilliant person, was working for the Attorney General at the time, walked up to me and said, "Hey, your entire presentation violates the First Amendment." And I looked at her with the weird face. I was like, how could that be? Well, she said, don't people have freedom of speech? And when you're deleting those comments as a government agency, could that be illegal government censorship? Well, of course, I had to look into it because that's what I was supposed to do. Answer to that question is not technically. You have more leeway to moderate comments on social media if you are a private entity versus being in the government. But even so, government agencies have the ability to moderate based on the relevancy of the content. That means those work-at-home schemes, enhancement products, meet people ads, and all that annoying stuff that gets commented on certain posts, those can be deleted, as long as you indicate so in your social media policy. However, a government agency has to make a policy with these considerations in mind. Think about this. If you're just deleting negative comments, from a PR perspective, what would that do? What does that show? That shows that you like to cover things up, as opposed to replying and potentially interacting with the customer, telling them things like, oh, could I learn more about this? Let's try to rectify this. And at that point, you can offer to take the conversation offline, either to an email or to the place like what Shemeka was pointing out with Walmart, where they have a specific page where you can take customer complaints. And of course, an apology is always, as always do, always helps out. And like I said, spam can get deleted. If you are in Virginia, you do have your special duties. Basically, if you want to have a social media policy, if you want to interact with people, consult with the AG's office or your locality's lawyer. So government agencies have special duties right here. And here's a place where basically the National Association of Chief Information Officers, they have this great thing on social media policies in their social media brief. I know the link is 3 years old, but most of the information is still relevant. And it basically does what we did with socialmediagovernance.com, but makes a specific twist towards governments. And this is where you can explore those issues such as free speech, privacy, and relevancy issues that affect your policy. A special word about government-regulated industries, basically electrical co-ops, if you deal with them, water companies, that sort of deal. If you're in an industry heavily regulated by the government, you may be subject to different free speech standards in addition to separate advertising regulations. All that stuff that applies previously also applies in the social media world. How about contracting for the government? One thing you want to be watchful for is if your post speaks for the government. You probably should not do that. In any case, consult with your government agency that you're contracting with, ask for a copy of their social media policy, and consider an internal policy that mirrors as much as possible, and basically that gives you guidance on how trigger events, how to react with certain trigger events. You may even want to plan on who comments on how a post happens when dealing with a government contract. A little bit about, we also went through the, one of the things, we did comment on this previously, but the Chief Information Officers Organization had basically an 18-point checklist of things that your social media policy should add. We talked a lot about who owns what. Can you publish things? If you're publishing a blog post or a Tumblr post, yes, that'll need permission too. Another issue is creating contracts accidentally. You don't necessarily want to say, hey, we can do that for you. That's something where you may create a contract. Be careful about that. And of course, defining the forum, which is always critical. We also discussed litigation and record holds. Sorry about that. Basically, we have tons of CLEs about this that go around the state, even some around the country that deal with this. But we have litigation we have record holds. And litigation, we talk about that a lot. Basically, in your policy, you want to define what is open based on your employees' posts on behalf of their company. Remember, government agencies can subpoena you. Divorce lawyers may also place a subpoena duces tecum, which we all know means come with documents. And, of course, there's always investigations, criminal investigations. Of course, when I talk about analytics, traffic management, your social media people and your marketing people will always want to know how are the people interacting with your company. Facebook, Twitter, all these companies discuss this sort of stuff. They are able to provide this for your clients. Just be upfront and transparent with your users that we actually collect your information to figure out how we're interacting with our audience and how people are reacting to our stuff. And of course, the old adage, if you're posting personal stuff from a work computer, that is also discoverable at any time in even public record searches. I used to do that in a previous life, reading emails, maybe an occasional social media post from company executives during SEC investigations on behalf of private clients, and just reading the emails, nothing else, just looking for evidence. And yes, we got to read all the salacious stuff. So tell your employees to think twice, or there'll be a bunch of lawyers in a back room laughing at what you do. So let's talk a little bit about employee conduct and behavior. You'll never be able to control everything your employee says on social media. Don't count on it. Your bosses may want to manage everything, but be aware of the legal hurdles. At no time should you ever ask for login information. And preferably, you should not be friending your employees on social media. That adds a layer of sketchiness on the one hand, and it also just opens yourself up for National Labor Relations Act violations, for example. That's your monitoring employee activity, particularly if your employees are not happy about a condition at work or the way something went. If you then fire them, but if you're a friend of theirs on social media, yeah, that's going to give us work. Let's just put it, let's make it a positive. It's going to give everybody in this room work. So yes, we are coming up towards the end of the time here, so I want to, I will make one last point here, and we're going to talk about privacy and control of identity. Basically, we have a law here that was passed in 2015. I'm going to basically go all the way down to the bottom. Federally, there's the Electronic Communications Privacy Act. That's a very old law. But of course, Virginia has this law passed last year. It's 40.1-28.7:5. Basically defines what an employer can and cannot do to an employee. Yeses equal viewing public posts. If you're investigating somebody and you just see all their posts on social media without doing anything, that's discoverable. But and of course, you can have an employee disclose their username and password when, and this is a very, very limited when, a formal investigation is occurring into federal, state, or local law, or an employment policy that the social media is linked to the allegation. So in essence, you just can't say, I'm opening an investigation. There has to be a policy about investigations in your employee handbook or in your employee contract. That's how the investigation gets opened. It's a formal investigation. This law does not apply to employees set up accounts at employer requests or when an employee is impersonating an employer. Fun. Lots of fun. But of course, you cannot require anybody to give passwords or usernames. So in the meantime, since we're getting close to the end, Shemeka, if you want to make a brief point about advertising, because you want to do it from here?
Yeah. All right. So truth in advertising. Everything that applies to print media, radio advertising, newspaper advertising, also applies to social media advertising. And if you are going to advertise on your social media, you need to be aware of the background of law that also follows that. That would also include Federal Trade Commission rules on truth in advertising, all of those things on that website. Contest or sweepstakes entries as well. So any post that you put up, if it's an advertisement, any disclaimers or anything of the like can't necessarily be in a separate post. So if you're going to send a thing about contests, like win a new car here, in the next post you can't say, let's see all of these rules. No, they have to be in the same post so that you can understand the rules and everything before someone commits to winning a new car.
Can I interrupt and just say, somebody who may be seeing that will not see it as two consecutive posts, but they may have a post and then a couple friends and then the disclaimer. And the FTC does not like that.
That's when you want to keep them together. Okay, and can't spam rules, does it apply to messages? Those things are just like emails or anything else. So any private messages you send, Facebook Messenger, direct messaging, any of that, that all applies as well. Next if you are going to do any advertising or endorsing of products, you have to say if you are a company, employee of that company, you have to disclose your relationship. If you are doing advertising for someone else, you obviously, if you have a relationship with them, you have to disclose that relationship. Our recommendation, one social media platform per brand. So, and that means, it's, again, easy to monitor, make sure there is a need for the regular activity, and again, the more accounts, the more risk and headaches for you. Yes, the FTC is watching you and all of their foreign counterparts. So be clear, use ad or sponsor to make it clear that anything or you are advertising on your page. Again, don't hide the relationship, no matter how minor. This is an article there about the Federal Trade Commission cracking down on social media advertising. And you just want to make sure that it's very clear to the person that you are endorsing something else, and basically the relationship between your endorsement and the other thing that you're endorsing, or even if it's yourself. And managing risk, okay? So this is kind of the technical part. Obviously, again, we want to emphasize creating and maintaining and reviewing your social media policy and the things that go along with it. And then kind of a little bit of a technical thing, passwords. Do not share your passwords with those who are outside of your organization, like it's family members and friends. So you can get close to me real quick. You don't want to do that. Obviously, use strong passwords that include characters and or numbers. Make sure the passwords are shared between the people who are going to monitor your social media accounts. It would probably be better if other employees didn't just have access to them, because then you have to make sure that they will no longer have access to those social media products once they leave the company. So you want to keep a managing of the account access, cyber insurance. You should probably.
Yeah, I get it. Get the cyber insurance.
It's a long kind of information, but again, the takeaways: share, share, share. Let people know what your plan is. Have a plan. Figure out who owns things, the content or the account. So you're very clear about those things in your policy. Moderation. Define what and how to moderate so you know exactly what can be posted and what can be taken down because it violates the terms. Don't forget the law. Remember what applies to you and is cited in your policy, obviously, for your employees as far as employment is concerned. And lastly, and most importantly, think before you post. Think about your audience and how they react. Obviously, you might want to have someone who acts as a go-between and monitor those things before they come from your head straight to the internet. You might want to have an in-between in that point in time. But other than that, I think that's everything.
We made it.